Fowler against Her Majesty's Revenue and Customs. This appeal is about the interpretation of a double taxation treaty. Double taxation treaties are designed to avoid the injustice of people being taxed in more than one country at the same time on the same income. The UK has double taxation treaties with many other countries, including South Africa. The current UK-South Africa Taxation Treaty, which I'll call the Treaty, came into force in 2002. It is modelled on the OECD Model Tax Convention, which is widely used to avoid double taxation around the world. Mr. Martin Fowler is a professional diver. During the 2011-12 and 2012-13 tax years, he did diving work in the waters of the UK continental shelf. But he was and remains resident in South Africa. The UK's tax authority, HMRC, seeks to tax Mr. Fowler on the income he received for those diving activities. This depends upon whether he was working at that time as an employee or as a self-employed person. The treaty provides that self-employment income can only be taxed in the country where the taxpayer is resident, here South Africa, but that the income of employees may be taxed in the country where it is earned, here the UK. HMRC and Mr. Fowler cannot agree whether he was at the time an employee or self-employed, and that remains to be decided. But Mr. Fowler says that this does not matter. Even if he was an employee, he says, correctly, that UK income tax law treats him as if he was self-employed. This special deeming provision was enacted because employed divers of his type used to pay their own expenses, and it was considered that, by deeming them to be self-employed, it would enable them to deduct those expenses before taxation in a fairer way than if they were treated as employees. Article 3 of the treaty provides that terms used in the treaty should, unless the context otherwise requires, be interpreted by each country in accordance with the meaning of those terms under their own income tax law. So Mr. Fowler says that even if he was really an employee, he should be treated by HMRC as self-employed under the treaty, and therefore taxed, if at all, in South Africa and not in the UK. The Court of Appeal, by a majority decision, agreed with Mr. Fowler, but HMRC have appealed to this court. We unanimously allow the appeal. I give the leading judgment, with which all my colleagues agree. In summary, our reasons are as follows. First, the provisions of the treaty are meant to be applied to the real world, rather than, if different, the fictional world created by UK income tax legislation, where this type of employed diver is deemed to be self-employed, unless Article 3 of the treaty compels the opposite result. Secondly, the UK deeming provision, which treats divers of Mr. Fowler's type as if they were self-employed, does not do so by redefining either the terms used in the UK's income tax legislation generally, such as employment, or the relevant terms used in the treaty, such as trade or enterprise. Rather, it uses such terms in their usual meaning, and then builds the deeming provision on top of them. Thirdly, the UK deeming provision is not designed to determine whether the income of qualifying divers is or is not to be taxed, even in the UK. Rather, it adjusts the burden of the tax by allowing a more generous deduction of expenses. Therefore, to apply that deeming provision so as to affect the provisions of the treaty about the taxation of employees and the self-employed would be contrary to the purpose of the deeming provision and also contrary to the purposes of the treaty. Thus, if Mr. Fowler really was an employee in 2011 to 2013, the income from his UK diving activities will be taxable in the UK.